Hello, you wonderful people. I hope you have nothing to complain. Let's talk about one of the most serious topics in the world right now. I'm Adam. I've studied law, writing now my PhD thesis in the fields of constitutional law, tax law, and European law. And my goal on this channel is to explain legal matters to you in a comprehensible manner. And today's topic will be about the North Korea crisis and whether or not the US would have the right for a preemptive strike. So basically, every week the world is facing new threats by North Korean leader Kim Jong-un. North Korea is making many nuclear tests. They recently shot a missile right over Japan. They're threatening the US territory of Guam. And on the sanctions imposed by the UN Security Council, they just responded with new and even harder and harsher threats than just before. Now, US President Donald Trump already said in a statement when asked before what he would do when threats by the government of North Korea continue. And he responded like this.
North Korea best not make any more threats to the United States. They will be met with fire and fury like the world has never seen.
So that makes the question whether the US would have the right for a preemptive strike pretty important and actually pretty current, as the world is concerned whether or not North Korea is actually serious with making those threats. Now, from a legal point of view, the UN Charter is what is applicable here. And Article 51 of it states that every nation would have the right for self-defense. And the situation, whether or not you would be in self-defense, was defined by a lawyer called Daniel Webster. He was American and he stated his formula, his test in 1841 after the so-called Caroline crisis. And it says that an attack has to be instant, overwhelming, and leaving no choice of means and no moment for deliberation. And this test, developed in the 19th century, was actually confirmed right after World War II during the Nuremberg trials. And this test actually means that an attack has to be really occurring right now. And in nuclear terms, that would mean that a nuclear missile would have to be on their way so that Japan or the United States would have the right for unilateral self-defense. In my opinion, and in the opinion of other lawyers as well, such a test would be pretty outdated. It stems from the 19th century. It may have been current there when armies and ships moved much, much slower than missiles do today. Plus, an army or a ship that is coming would not have the massive impacts a nuclear bomb would have on a single territory. The outcome of a successful attack like this would just be catastrophic. So that's, of course, a legal question whether this Caroline test would be applicable when one side of the equation would actually make nuclear threats like North Korea does. A pretty interesting fact about international law, and in this case, this is treaty law, as the UN Charter is basically a treaty between nations, is that it's not stiff. So the wording is not so static, but rather in flux. It's very important how the parties, which in this case are the nations that signed the UN Charter, would actually interpret it and would actually live it. This means we would have to check similar cases that would actually be applicable also in this case. And there was one similar occurrence in 1981 when Saddam Hussein, the then dictator of Iraq, built up nuclear facilities, and the state of Israel feared a threat by said Saddam Hussein and made a preemptive strike against his nuclear facilities. Most of the nations by then condemned the strike by Israel, so we would have to say that preemptive strikes against nuclear facilities and nuclear threats wouldn't be a part of the law that is actually lived by or that has developed through the ages. But lately there have been also nuclear threats by nations, nuclear facilities built up apparently by Syria and especially Iran. And Israel made another attack on Syria in 2007, and the reaction of the world against this was pretty much silence. Now, there have been rumors about strikes against nuclear facilities of Iran by both Israel and the United States, and also this hasn't been investigated by the United Nations and not have been condemned by most of the nations. Yet, being silent towards an action of a state doesn't mean that you appreciate it or that you would confirm it as legal. We couldn't interpret it as in that case. But as I said, international law is in flux. So at first you condemn one action, then you might remain silent, and maybe in the future would even appreciate it as legal. So when we're talking about the situation between the US, Japan, and North Korea, we will talk pretty much about the gray zone in international law. Since when the United States would make a preemptive strike, the reaction of the world to it would be very, very important for future cases like this. If the world would condemn it, that will be pretty much condemned for the future. And if the world would acknowledge the fact that this was basically self-defense after the threats by North Korea, then this would be pretty much a case for the future that you could do that against the threats of nuclear strikes. However, this amount of legal uncertainty that the international law presents in especially a case like this is very concerning, because we're talking about nuclear strikes. We're talking about one of the worst outcomes and crimes imaginable on this planet. And the principle of legal certainty is actually super important, because you would need to know what to expect legally in specific cases. You need that as a person walking on the street. You would need that as a state, what consequences your actions would have, so that you would have this, at least the knowledge what outcome your actions might produce. Now, we don't have that in this case, and this is what makes it so scary. Now, there's of course the question, could the UN Security Council, after imposing those sanctions and seeing that actually the sanctions remain effectless, organize and make a resolution about a preemptive strike against North Korea? And here the UN Charter actually says that the Security Council could make a strike if that secures world peace. Now, that's a question, if you would actually secure world peace by attacking a nuclear power, even though this nuclear power is pretty much an empire of evil, and especially since it's ruled by a dictator. So when the dictator is cornered, he might actually strike against Japan, South Korea, or the United States, which would mean that the preemptive strike wouldn't actually secure world peace, but would rather cause much more destruction. So that would be also a legal question, whether you could prevent a huge nuclear war by causing a comparatively little nuclear attack. And I don't think this question would have anything to do with securing world peace. But as I said, this example makes it clear where the loopholes, where the uncertainties in today's international law are. You basically don't have any legal response, any legal measure against a state that is illegally summoning nuclear weapons. And I for sure hope that there would be a diplomatic solution for this problem, for this issue. And cornering this nation might just cause a situation where North Korea would have nothing to lose, and a nuclear power with nothing to lose would be pretty dangerous. What are your opinions on this? Share that to me in the comment box down below. Give this video a thumbs up or thumbs down, whatever you like. Actually, I have a German speaking channel where I discuss topics like this, but also like small legal tips. I'll leave you a link. Check that out if you understand it, if you understand the German language. I try to upload an English speaking video on international law like once a month. If you have any suggestions for topics, leave that in the comment box down below as well, and subscribe to this channel. I would very much appreciate that, and see you next time. Bye.